Let's take a look at Marshall's main arguments and consider some opposing arguments and implications. First, Marshall argued that the bank was constitutional because historical precedent confirmed it. Congress had enacted the first bank and the President approved it. Congress had also authorized a second United States bank. However, it can be argued that just because the bank was authorized by Congress, that didn't answer the question as to whether the bank was constitutional. It simply meant that its constitutionality wasn't as yet challenged in court. Second, Chief Justice Marshall addressed Maryland's argument that states retain ultimate sovereignty because they ratified the Constitution. He argued the people are sovereign, not the states. Marshall wrote, "The government of the Union is emphatically and truly a government of the people. In form and in substance, it emanates from them. Its powers are granted by them and are to be exercised directly on them and for their benefit." From this, Marshall reasoned, the government of the United States, then, though limited in its powers, is supreme, and its laws, when made in pursuance of the Constitution, form the supreme law of the land. Anything in the Constitution or laws of any state to the contrary notwithstanding. Therefore, from Marshall's point of view, the people, upon ratification of the Constitution, had determined that when a federal law conflicts with a state law, the federal law reigns supreme, as long as that power was within the powers granted to the federal government. Legal scholars favoring a states' rights position have always suggested several flaws with Marshall's in the name of the people reasoning. First, they point out that the U.S. Constitution did not have to be ratified by all the people. According to Article 7 of the Constitution, only approval by 9 states would be sufficient for ratification. Also, the Constitution was ratified not by a national vote or by state legislatures that would be representative of the various communities within the states. It was ratified by state political conventions. Moreover, women did not have the right to vote in America until 1920. Also, slaves and free blacks were excluded from the political process at the time, so the whole people could hardly have ratified the Constitution. Third, Marshall then went on to address the scope of congressional powers under Article 1 of the Constitution. Marshall admitted that the Constitution does not enumerate a power to create a central bank, but this did not limit Congress's power to incorporate a bank. His response was that the Constitution couldn't cover everything. He wrote that the Constitution's nature requires that only its great outlines should be marked, its important objects designated, and the minor ingredients which compose those objects be deduced from the nature of the objects themselves. He added, "We must never forget that it is the Constitution we are expounding." Those favoring a states' rights position would later point out that the Supreme Court had no right to even expound on the Constitution. But even if the Constitution is an outline, not a blueprint, that still doesn't prove that the bank is constitutional. Such reasoning would allow the Constitution to be open to subjective interpretation and lead to the possibility for powers to be found that were never even considered by those who framed the document. Who is the one who deduces which are the important objects and which are the minor ingredients? Who fills in the outline? Fourth, to answer this, Marshall adopted the Hamiltonian means-end argument. The congressional power granting a corporation was not an end, but only a means of accomplishing other powers. It therefore need not be expressly mentioned in the text of the Constitution. There are therefore non-enumerated implied powers, Marshall wrote. But it may with great reason be contended that a government entrusted with such ample powers must also be entrusted with ample means for their execution. But that instrument, the Constitution, does not profess to enumerate the means by which the powers it confers may be executed, nor does it prohibit the creation of a corporation. Let the end be legitimate, let it be within the scope of the Constitution, and all means which are appropriate, which are plainly adapted to that end, which are not prohibited, but consist of the letter and spirit of the Constitution, are constitutional. Marshall reasoned, a privately incorporated bank was appropriate for facilitating constitutional powers. It was not prohibited by the Constitution. This is a power implied by the Constitution, and therefore the bank is constitutional. Many argued that Marshall's line of reasoning would eventually allow the national government the power to do anything, thus rendering the states powerless. John Taylor, U.S. Senator from Virginia, strongly objected to Justice Marshall's decision, and in 1820 wrote this concerning Marshall's argument. In short, this mode of construction completely establishes the position that Congress may pass any internal law whatsoever in relation to things, because there is nothing with which war, commerce, and taxation may not be closely or remotely connected. But the question remains, who decides what are appropriate means? Fifth, following Hamilton, Marshall argued that the Necessary and Proper Clause found in Article 1, Section 8 of the United States Constitution gives Congress the right to determine the implied powers appropriate for carrying out its enumerated powers. Article 1, Section 8, Clause 18 states, "The Congress shall have power to make all laws which shall be necessary and proper for carrying into execution the foregoing powers, and all other powers vested by this Constitution in the government of the United States, or in any department or officer thereof." Marshall defined the word necessary here as convenient or useful and not as a limitation on congressional power. In other words, the Necessary and Proper Clause allows Congress to adopt a means, an implied power, as long as it is rationally related to the enumerated power and not forbidden by the Constitution. For Marshall, the establishing of a bank or creating a corporation was an implied power of Congress that was a necessary and proper means for carrying out the powers that are enumerated. Congress can impose and collect taxes. This is an enumerated power. Incorporating a national bank is an implied power and a necessary and proper means for carrying out the collecting of taxes. Therefore, the bank is constitutional. Marshall's broad interpretation of the Necessary and Proper Clause was in complete contradiction to the narrow or strict interpretation posed by Maryland. Maryland's view of the clause was that Congress could only pass those laws which were absolutely essential in the execution of its enumerated powers. The potential danger of this interpretation of the Necessary and Proper Clause was recognized as early as the writing of the Constitution. Future President James Monroe, speaking at the Virginia Ratifying Convention, understood the sweeping clause to mean that there is a general power given to them, Congress, to make all laws that will enable them to carry their powers into effect. There are no limits pointed out. They are not restrained or controlled from making any law, however oppressive in its operation, which they may think necessary to carry their powers into effect. Representative John Clopton in 1806 proposed amending the Constitution because of the danger he saw in the possible abuse of the Necessary and Proper Clause. He said this, "The construction which has been given to this clause in the cases alluded to was that it conveys to Congress a right to make any laws whatsoever, which they should determine to be expedient for carrying into execution the powers enumerated in this section, or in any other part of the Constitution." The debate over the meaning and implications of this clause, which started in 1788, continues to this day. Sixth, finally Marshall argued that the taxing of the bank by Maryland was unconstitutional. Borrowing an argument from Daniel Webster, he said, "The power to tax involves the power to destroy." The bank was necessary for the Congress to carry out its powers. If the bank could be taxed out of existence, then a power of Congress could be destroyed by the states. One aspect of the case that is seldom discussed is Marshall's lack of response to one of Maryland's key arguments. Maryland argued that since the bank was a private entity, Congress did not have the right to bestow federal immunity on a public corporation. The bank was functionally free from congressional control, yet clothed with federal sovereignty. Joseph Hopkinson, attorney for Maryland, stated, "Can an institution then purely private and which disclaims any public character be clothed with the power and rights of the government and demand subordination from the state government in virtue of the federal authority? It will be seen. It cannot be done." The force of this argument should not have been missed. Can the powers enumerated in the Constitution be extended to a private, profit-seeking institution? Can Congress delegate its authority to a private business? Maryland said this was not constitutional. Marshall never adequately addressed this argument. He simply said the relationship could exist. At the time, the Supreme Court's decision was not popular in many sections of the country. Thomas Ritchie, editor of the Richmond Enquirer, the paper Thomas Jefferson said was the best that was published or ever had been published in America, wrote this: "We solemnly believe the opinion of the Supreme Court in the case of the bank to be fraught with alarming consequences, the federal Constitution to be misinterpreted, and the rights of the states and the people to be threatened with danger." How did Marshall's opinion play out practically at the time? In February 1819, while McCulloch v. Maryland was before the U.S. Supreme Court, the state of Ohio imposed a $50,000 tax on each of the Bank of the United States branches within the state. Ohio sent a deputy to collect the tax by persuasion if he could, but by violence if he must. When the deputy was denied payment by the bank's management, he leapt over the counter, strode into the bank vaults, and helped himself to $100,000 in paper and specie. The Bank of the United States sued the deputies and the state of Ohio, relying on Marshall's opinion. The Ohio state legislature responded by refusing to comply with the court's decision. We are aware of the doctrine that the federal courts are exclusively vested with jurisdiction to declare, in the last resort, the true interpretation of the Constitution of the United States. To this doctrine, we can never give our assent. The Ohio legislature's opinion was that Marshall was wrong, and Ohio did not have to comply. In 1819, the opinion of the Supreme Court did not necessarily carry more weight than the opinions of the President, the Congress, or the citizens of states. The states continued to harass the bank until Andrew Jackson refused to renew its charter in 1832. By the end of 1833, most of the government's money had been moved out of the Second Bank and into state banks. In 1836, the charter of the Second Bank expired, and the bank ceased to exist. The sharp divisions concerning states' rights versus federal power would intensify until 1861. The war between the states in 1861 would decide many of the questions raised by McCulloch v. Maryland. President Woodrow Wilson alluded to this when he said, "The war between the states established this principle, that the federal government is, through its courts, the final judge of its own powers." However, such a statement is not a little troubling. In 1803, Jeffersonian legal scholar St. George Tucker, in his essays, A View of the Constitution, wrote, "If the federal government ever became the final judge of the limits of its own powers, then constitutional liberty would become an empty phrase. The federal government would inevitably conclude that there are, in fact, no limits to its power." Thank you for watching Historical Spotlight. You can watch more of our historical videos on www.historicalspotlight.com.